in your specialized field of family law, right? The majority of judgments relate to matrimonial disputes, inheritance, domestic violence, maintenance, and other gender-related issues. Do these judgments reflect the worldview of the judges themselves, or do they have an understanding of the issue in hand?
So I do believe...
I'd really love it if you could talk about the Karam Bhumi judgment.
Oh, okay. Okay. So, yes, so the two are related. So I do believe that in, and I've mentioned this earlier, as Justice Chandrachud said, and as also Justice Sridevan has mentioned, judges have personal perspectives, but personal perspectives, in fact, even though I realize that it's a process to transcend those, and that you are supposed to, because that is the discipline and that is what you're trained to do. But very often I find that it's not just a question of being this way or that way. Very often a judge could well be only a victim of his or her socialization. And that, when you are being judicious, then surely an integral part of that training or that discipline that you are applying means that you will have introspected to transcend your personal socialization. And I find that lacking as a family lawyer. And I have to confess that I have a long litany of complaints, not only as a feminist lawyer or feminist lawyer, but also as a family lawyer. Because this is an area of law which is treated as a, somehow, I don't think I'm oversensitive to it. I don't think there will be any strong disagreement, but it's treated as a soft area of law. It's treated as an area which is all good sense, gharelu, mamla, warm, fuzzy feeling, we will get it right type of thing. Not realizing that there's actually hard law that needs to be applied to have substantive justice to a family. And the magnitude of this area of law is that every family has had truck with law from family law. May not have had even a traffic challan otherwise, but you will have dealt with while making a will, while dealing with your partitions, while divorce over custody. It's not even 3 degrees removed, it's just about 2 degrees removed. And that is something which unfortunately judges today, many judges are not responding to with the robustness which would truly help this subject, number one. Number two, if they did respond with the robustness that is required and had precise, clear clarity of thought which could give decent precedent which could then continue with clarity, it would also reduce backlogs, because a lot of time goes in sheer the labyrinth of procedure. There is this judgment to support this view, but there is also that judgment to support the other view, and yet there is very clearly a position that we can take in between. And that is something that right now the judges are not being able to do, primarily in the lower courts, because of the bureaucratization of, I do believe, of the lower judiciary, where they don't feel bold enough to actually take steps which otherwise they might do. You find that some of them do remarkably well when they come to the High Court. Karam Bhumi is an instance of victim of socialization, and Karam Bhumi is an instance of feeling that morally doing the right thing is also legally the right thing, not understanding that morally the right thing for that judge was in fact not even morally right thing for the woman in the particular case, and in any case it wasn't the legally right thing at all. So in that context, the case was about a woman who had left the United States because of domestic violence and had come home to her parents' house. And then the High Court, in a habeas corpus petition moved by the father, the High Court ordered for the child to be returned but then did, and I understand that from deep concern, I understand the value of that sentiment as well, a very carefully drafted judgment which made sure that if she returns, there must be so much that would be paid to her every month and so on and so forth, so that she is not financially troubled, etc. The child is not separated from her. But the operative part was she must go back. So the sentiment was sound, the steps were practical, but it was almost as if it was worked backwards, because intuitively the understanding was that she must go back. And that was something that, while it's a complex exercise, I'm not discarding or dismissing or even diminishing the exercise at all. It's a complex exercise of balancing competing rights. And in this particular case, the rights of the mother, the personal rights of the mother to choose to stay in a particular place, the judge overlooked, while still arranging for her protection in the new place where she would return and deal with the system there. Now, but while trying to justify it, not finding a jurisprudential term which could cover it, he used the word Karam Bhumi, which I found to be problematic, because it would to my mind have been a more important exercise to then have truly grappled with it and grappled with the issue of where should a matrimonial home be, should it only be where the child is born, and so on and so forth. Of course, the Supreme Court eventually dealt with it and has taken a point to say that habeas corpus cannot decide something so complex. So go through the regular due process, and so whatever cases are in the family court, you go through that process. If the family court decides, for whatever reason, while balancing those rights after proper evidence, that you have to go back, then you will have gone through due process and we take it from there. So right now it's one step forward. Of course, I understand the pushback from the fathers' rights programs have been very strong, and I'm not diminishing it. I understand the value of that too. But the important thing here is, and this is the crucial question which I keep, so I'll just finish with that, because that's what the conundrum I constantly deal with while dealing with best interest of child means she must have both parents. And yet, that the father wants to insist has to be 50-50 child. As Vrinda says, bring the child to the creche, I'll bring to the office. To me, that's actually a problematic, because you take the child to the office the day I too, as the mother, can work the hours that you work, and so that then I can earn the amount you do. But if you want to, you can't decide that it's easy for you to afford the creche and take me to your plush office, take the baby to the plush office, and leave the mother who in that many years has perhaps chosen, been the primary caregiver, stepped back, done many things, suffered a career, will never have the earning capacity that you have. Somewhere it is an economic issue which needs to be addressed. And to my mind, the both. And yet, you can't then say, come back, I'll pay you $1,000 a month and you live in America so that I can have 50% of my child. That's not a solution either, because it lacks dignity, which Justice Chandrachud has written so eloquently about. There are no answers. We are in the process. But in the process, the problem I find is that the very court which takes us 3 steps ahead on this trajectory of gender sensitivity or rights sensitivity takes in another court. So it's 20 however many courtrooms in one courthouse, and really the outcome they can't be because the judges are humans. So that mean we have not found yet, and therefore I don't see a clear trajectory. I don't know. If we are going this way, it sounds positive, but what will it be tomorrow? I don't know. So 2016, in your program earlier this afternoon that we did on the feminist rewriting program, we analyzed a 2016 judgment which has the most appalling generalizations on the issue of gender stereotypes. you know, and that is 2016, and yet 16 years ago you had great steps forward. Now 2018, there's been a slew of very important judgments in the last 3 weeks. How is this an indication of where we will be next year? That is the certainty which I find that I can't see and I would love to have.